This is Manager Otoo, Institute for Leadership and Strategic Management, Africa. I'll be addressing the issue of employment types and how to discharge an employee through termination of appointment or summary dismissal. There has always been an issue between the employer and the employee. So addressing this issue today, I think I'm on course. Let's start with the types of contract or employment contracts. There are two major types. The first one is contract of employment, and the second one is contract for employment. That is contract of employment and or contract for employment. Contract of employment is a full-time job. That is permanent job. Any job which exceeds the relationship between employee and employer exceeds a period of 6 months or 6 months and over. So even if you are permanent staff, casual, even if you are casual or part-time worker, the moment you work between the period of 1 month and up to the 5th month, you are a temporary worker. But the moment it enters the 6th month, automatically you are a permanent staff. Get it right. If you work with someone between 1 month to the 6th month, automatically you are a permanent staff. If the employer do not want to make you a permanent staff, then the employer must end your contract. Once it is ended on the 5th month and he asks you to reapply, then the process starts over again. But the moment you continue to work and you enter the 6th month, automatically you become a full-time employee, and whatever all other members of staff are enjoying, whatever benefit that goes to them, you equally deserve it. So contract of employment is when you engage the services of another for a full-time job from Monday to Friday, as we've been doing most of the time. Then that is contract of employment, and you must take your appointment letter. This reminds me of something. Some employers feel they are too smart. They fail to provide or issue appointment letters to employees, and they go about saying, after all, I do not have contract with him, I have not given him appointment letter. Trust me, whether you have given him appointment letter or not, the question is, has he or she done something for you? Has any transaction taken place? Is there evidence that he has done something for you? The moment there is evidence, then you, the employer, rather may be in trouble, because whatever he says, the possibility that what he says will be accepted is high. So long as you have engaged him and you do not state clearly terms and conditions in appointment letter, he can even chip in things that were not part of the contract. So I advise all employers, it is better you issue appointment letters to employees before they start the work. And it is advisable as an employee to accept or take or insist on your appointment letter before you begin to work with any person. Do not focus on trust. In business, there is nothing like trust. We use principles and procedures. Make sure your appointment letter is in your hands. You understand every section of it, every part of it before you start the work. Do not let the salary be your most focus. Think about security and other legal issues. Now, the next one is contract for employment. This is where you engage the service or services of external persons, let's say consultants, experts, to perform a duty on your behalf For instance, when you engage an external training consultant to train your members of staff, the moment the contract ends, he goes back. That is contract for employment. But when you employ a training and development manager to play key role continuously on daily basis from Monday to Friday, and you pay him at the end of the month, that is contract of employment. If you engage the services of an external caterer to provide food services to your workers, that is contract for employment. But if you engage the service full-time of a caterer who is part of the business activities, that is contract of employment. So contract for employment is not same as contract of employment. The things that goes into contract for employment is not same as contract for or of employment. Now, I believe this explanation is very clear. Let's move on to the next one, which is discharging an employee through termination of appointment or summary dismissal. These two terms are not same. Human resource practitioners, organizational psychologists, or general managers, managing directors must understand and be familiar with the differences. These terms are not used same. If you are an HR practitioner and someone's actions call for termination of appointment and you use summary dismissal, it comes with legal implications. Or if his actions call for summary dismissal and you use the term termination of appointment, it calls for legal implications. I will explain them. Now, termination of appointment is used when there are minor offenses. Minor offenses. And before you even write a termination of appointment, you should have queried the person. This is a process or the procedure. You must query the person, give the person the opportunity to give reasons why he did what he did. He gives reasons why he did what he did. After giving reasons, if it doesn't make sense or is not convincing, then you give what is called the first written warning letter. It may be warning may be verbal or written. If it is verbal, you need to record for him to assign. If it's by word of mouth, you must record his signs. You sign. Whether it's written or verbal, it's still a warning. It's still a warning letter. Now, you give him the first warning letter. He repeats same thing or similar thing. You give him a second warning letter. Now, if he does another thing or the same thing, repeats it, you give him the third one, which is not a warning letter. It is called termination of appointment. Termination of appointment. And under termination of appointment, you give reasons why you are terminating his appointment in the letter. Now, the third one is not a warning letter anymore, because at the workplace, you are not there to be writing warning letters. We are not there to be writing warning letters and queries. We give you the first warning letter, second warning, the third one automatically is termination of appointment. So any employee who keeps repeating what he has been warned against, the third one automatically is termination of appointment. And you need to give reasons why you are terminating his appointment. Let's look at few things that may call for termination of appointment. When there is physical assault on the company premises, it calls for termination of appointment. Gambling on the company premises, it calls for termination of appointment. Malicious spreading of false information or rumor about the company, it calls for termination of appointment. Negligence of duty calls for termination of appointment. Inefficiency calls for termination of appointment. Immoral conduct and indecency on company premises calls for termination of appointment. Vacation of post calls for termination of appointment. Insubordination calls for termination of appointment. drunkenness on duty. We don't drink at the workplace. It's not a movie like Jackie Chan's movie, The Drunken Master. We don't drink at the workplace. You may be working in a manufacturing firm where you operate or with a sharp machine, which may chop off your hands or something that will end up causing harm to your body and then unnecessary cost to the company. So at the workplace, you don't drink. If you want to drink when you are off duty, you take all your alcoholic beverages you want to take, but not on the workplace. When you drink and you come to work, we shall terminate your appointment. Now, disrespect towards superior also call for termination of appointment. Disrespect towards external public of the company calls for termination of appointment. Habitual lateness to work, especially in this part of the world, Africa, where we do not work with time. We have no regard or respect for time. You come to work late continuously. They give you first warning, second warning, the third one calls for termination of appointment. Habitual lateness to work. And then any act which may bring the image of the company into disrepute calls for what? Termination of appointment. Any act which may bring the image of the company into disrepute calls for termination of appointment. Giving false testimony during investigation, depending on the degree, may call for termination of appointment. So now, I believe we are clear with the criteria or things that you do, offenses you commit that will end up calling for termination of appointment. Under termination of appointment, the human resources is supposed, or the person terminating appointment is supposed to give you reasons why your appointment is being terminated. And under termination of appointment, you are entitled to all entitlement, or you qualify for all entitlement due. So you have to contact the chief finance officer. Any entitlement that is anything that is yours, you qualify. Now, when we talk about dismissal of appointment, it also means the contract has come to an end. But the dismissal of appointment, this happens when you commit major offenses such as falsification or alteration of important records. That is summary dismissal. Falsification of alteration of important records is summary dismissal. If you're a chief finance officer, instead of chief finance officer or chief procurement officer, you turn yourself into TPO instead of CPU. TPO, chief procurement officer, or chief finance officer, TFO instead of CFO. Then you engage yourself in the falsification or alteration of important records. Then it calls for summary dismissal. Willful or malicious destruction of company property or employees' property on the company premises. Destroying company property or another employee's property on the company premises call for summary dismissal. Stealing, especially those of you in the banks, in the manufacturing firms, you mean stealing. Stealing calls for summary dismissal. It's a major offense. It's a criminal case. Embezzlement of company funds. Embezzlement, those of you with wide mouth, you bisect your mouth at any radius or any angle. Any money you want to swallow it. What is not yours, don't take it. What is not yours, don't take it. You swallow all the money. It's embezzlement of fund. You have a big tummy. You are chewing all the pork meat in the system. You embezzle somebody's money, it calls for summary dismissal. Conviction by court of competent jurisdiction for criminal offense. That is criminal offense. The moment there is evidence you have done something like that, it calls for summary dismissal. And then also collusion with an employer to cheat the company. You connive with somebody to do something against the company. It's summary dismissal. Fraud or bribery or corruption. Young men of today are willing to make money more than what their great grandparents made illegally, wrongfully. If you go into fraudulent act or bribery or corruption, it's a summary dismissal. Corruption means using office resources for your personal interest It does not matter how big or small it is. We have petty corruption and we have major bulky corruption. Petty corruption, when you even use office A4 sheet and office pen to write a personal letter to a friend, you are corrupt. When you use the office phone to make personal phone call, you are corrupt. Major corruption is where you accept boats, cow, big fat envelopes before you award a contract to somebody. You are corrupt. It calls for summary dismissal. Dishonesty is a major offense. It calls for summary dismissal. Serious act of omission or commission leading to great financial loss to the company, summary dismissal. Any act which seriously tarnishes the image of the company, summary dismissal. Disrespect towards superior officer, depending on the degree, summary dismissal. Now, under summary dismissal, it is not necessary to state the reasons why you are dismissing the employee. It is not necessary. It is not required. It is not important. If the person doesn't understand, he should take it to court. A typical example is sexual harassment. You harass a female employee sexually at the workplace and there is evidence, the CC camera captured it. You want us to give you reasons why we are dismissing you? No. If you don't understand, take it to court. We'll meet you there. Now, under summary dismissal, you do not qualify for any entitlement apart from your own personal contribution like Provident Fund A or any leave entitlement or any other thing that is personal. You can pick it up. But long service benefits or whatever it is, anything by the company, you cannot have access to it. This means if you are an HR practitioner and you use summary dismissal instead of termination of appointment, the person can sue the company. And if you use termination of appointment instead of summary dismissal, then the person also qualifies for his entitlement. You need to understand these concepts so that you don't make common mistakes. Now, to understand the grievance procedure and other human resources policies, principles, rules and regulations, manuals, contact the Institute for Leadership and Strategic Management, Africa, for your human resource policies. An organization without a policy is like a fisherman without a net. You must have policies, HR policies. Now, I also advise job seekers or employees, any organization that they do not have HR policies, do not waste your time there. These jobs or companies are referred to as 3D jobs. 3D jobs. 3D jobs. Dirty, dangerous, death warrant jobs. You are just wasting your time there. They only terminate your appointment or sack you wrongfully. Get organizations that believe in the human resources principles, rules, manuals, and regulations. If you want to enroll for or become a professional in human resources management, contact the Institute for Leadership and Strategic Management for our certified program. We have a certified business administrator with strategic human resource professional, and you can enroll for this course on a one-on-one or selected days or join the normal class. Our fees are affordable and flexible with flexible payment. Contact us on www.ilsmagh.com www.ilsmagh.com or +233 0244 660 982 +233 660 982. At Institute for Leadership and Strategic Management Africa, we just don't teach. We teach you to perform, and we help in developing managers for higher performance. Thank you so much for listening to us. Share our video and recommend to others. We have other programs that even if you hold JHS qualification, you can enroll for our AB UK courses, Association of Business Executives UK, with JHS certificate or without certificate, so long as you can read and understand English language you can enroll for our ABE UK program and also become a graduate. Thank you so much. We'll meet again.